Unless that occurs in my presence before me, court is not going to bring an action, okay? As far as why the people chose to implore some and not others, that's their business, but that doesn't negate the validity of the gag order. Marge Blanche, and, Your Honor, if that came out in our papers, that is absolutely not our position. Our position is that Your Honor has to find a willful violation beyond a reasonable doubt. And it is certainly appropriate for the court to take into consideration whether President Trump's conduct was willful beyond a reasonable doubt. The fact that, when he reposted the ones, Exhibits 3 through 10, the fact that he had reposted many others, and the people had not brought an order to show cause, it's not making a mockery of the gag order, it's a close call. Honor the court, well, what is it if your argument is not that somehow the validity of the gag order is waived, then what is your argument, because that's what it sounds like to me. Mr. Blanche, no, because the posts the court, no, the people did not bring an order to show cause for certain alleged violations, therefore, he's allowed to violate whenever he wants. Marge Blanche, Your Honor, the gag order prevents him or him causing somebody to violate the terms. Reposting an article from a news site or from a news program or, a New York Post article or the articles that are in Exhibits 3 through 10, we don't believe a violation of the gag order. The court, all right, so let's talk about that. That I want to talk about. MR_BLANCHEOK. The court, so tell me what case law you have to support that. Blanche don't have any case law to support that, but it's just common sense, Your Honor. How can it be that President Trump is prohibited from violating the gag order through his words or by causing another person to say something that he was saying? The court, all right. Marge Blanche, which is a big difference under the First Amendment under the Constitution. The court, all right. Where does it say that? Give me the case law. Marge Blanche, Your Honor, there is none. I don't believe the court. What I'm asking you, when we talking about these reposts, how does it get there? Does it get onto your client's Truth Social account? I post something and I post it on my account and then it winds up on your client's account. How does it get there? Marge Blanche, there is a group of folks that work with President Trump that when they see articles that they believe President Trump's audience should read, there is a mechanism. I'm not the court. What is the mechanism? Marge Blanche, so, I believe you click on it and you do something to repost it on President Trump's feed. The court, it requires some sort of action. Marge Blanche, of course, yes. The court, it's not as if? I'm looking for the decision that I read yesterday. It's not passive. There is case law that talks about the difference between passive conduct and what we're describing. Passive conduct would be if someone makes a post and it somehow winds up in your client's account without him or anybody else doing anything. Marge Blanche, that's not our position. The court, no, it's not your position, which means that someone had to do something. Marge Blanche, yes. The court, okay, so calling it a repost and suggesting that because somebody else wrote it and then miraculously it appears in your client's account that, therefore, your client can wash his hands of it. You said it's just common sense. I say it's just common sense. Marge Blanche, it's not. Judge, I'm not asking that President Trump wash his hands saying of it. The question is whether it's a violation. If it's unambiguously a willful violation of the gag order to take a news article that appears in whatever publication it's from and post it, as opposed to using your own words. The court, so it's your client's position that when he was reposting these things, he was not violating the gag order? Marge Blanche, correct. The court, so how do I know that that's his position, because you are telling me? Marge Blanche, well, Your Honor, I think that the court, are you testifying under oath that that's his position? Marge Blanche, Your Honor, I'm not testifying under oath, I'm making argument, Your Honor. The court, well, it's your client's position that at the time that he reposted anything to one of his accounts, he did not believe that he was violating the gag order? I would like to hear that. Marge Blanche, Your Honor, the court would like to hear that. Or do you want me to accept it just because you're saying it? Marge Blanche, no, I don't expect you to accept it because I'm just saying that. But what I would like you to look at here, Your Honor, is that there is a history of posting and reposting that have gone unchecked. And I agree with you that the people have a right to choose when they want to and when they don't want to bring an order to show cause, but that certainly goes to whether the court can find that it's willful. The fact that President Trump hasn't done it, the court just want to make you aware that the people presented 10 exhibits that indicated what their case law is. I understand what your position is. The people have presented that case law %, you have no obligation, of course, but you have presented nothing. Marge Blanche, no, Your Honor, we are in the middle of a criminal trial and you are asking whether I should put President Trump on the stand. Is that the question? Court, well, I'm just telling you that you have presented nothing. I have asked you 8 or 9 times, show me the exact posts that he was responding to, and you have been unable to do that even once. Let me ask you about Exhibit 10. The court, so this is Exhibit 10. It was posted on April 17th at 5:46 p.m. And it says, in quotes, they are catching undercover liberal activists lying to the judge in order to get on the Trump jury. Closed quote. And then it's attributed to Jesse Waters. Is that, in fact, what Mr. Waters said? Marge Blanche, he said, they are catching undercover liberal activists lying to the judge. At the time, I don't believe he and then not said in order to get on the Trump jury. The court, well, at the time that he reposted this, he had not said that? Marge Blanche, correct. The court, so your client manipulated what was said and put it in quotes, am I right? Marge Blanche, it was, I wouldn't use the word manipulation, Your Honor, but the rest of the quote is not part of the quote. The court, okay, my other question is, this is not a repost at all? Marge Blanche, no. The court, no, this is something that was said on TV and your client had to type it out. He had to sit there, use the quotation marks, the shift key and type everything out, and then add those additional words. So your argument that these are reposts and, therefore, they are not a violation, that does not apply to Exhibit number 10, is it? Mr. Blanche, number 10 is not a repost. Agreed. The court, so what is your argument as to Exhibit 10? Mr. Blanche, Judge, the argument as to Exhibit 10, it's ambiguous whether this statement violates the gag order. Again, we have to find a willful violation of the gag order beyond a reasonable doubt. And President Trump voicing his view that there were liberal activists trying to get on this jury is not calling on a particular juror. It's not in any way trying to threaten or intimidate jurors, just isn't, Your Honor. I mean, and there is note it's tough to read, especially because that night, Your Honor, remember talking about what's in truth, but on every single website that was in news form and in every single newspaper article, on CNN, on all the cable shows, there was full discussions about the jury, full discussions. And I'm not saying that that's exactly like what was said, but there is full discussions about the jury, so it wasn't in President Trump's truth. The court, Mr. Bove, do you want to speak to Mr. Blanche? Mr. Bove, yes, Your Honor. Thank you. Mr. Bove, thank you. Mr. Blanche, thank you. I'm looking, Your Honor, and I'm happy to bring it up to the court and share it with the district attorney. I don't have a printed copy, but I can get one. The court, that's fine. Just let me know what it is, Mr. Blanche, just to say what it is. It's a post from Jesse Waters from April 17th. It appears I'm looking at one that said 8:24 p.m., and it says, verbatim, the same thing that President Trump said on his truth. The court, but that's 3 hours after your client's post. Mr. Blanche, yes. The court, so it's irrelevant to that. Mr. Blanche, well, it goes to the court. There is no relevance to that. Do you have any case law that you want to hand up, any other arguments that you want to make to me at this time? Mr. Blanche, yes. Again, Your Honor, we said it in our papers, but now that we've had this hearing, it's worth ending on this point, which is that this gag order, we are trying to comply with it. And there is no doubt that we are here about 10 different purported violations. President Trump is being very careful to comply with Your Honor's rules. And COURTU, Mr. Blanche, you are losing all credibility. I have to tell you that right now, you are losing all credibility with the court. Is there any other argument that you want to make? Mr. Blanche, yes, Your Honor. If anything, the reposts and whether something can be reposted, an article written by a reporter can be reposted, and that is a violation of the gag order. That's ambiguous, and that's something that we certainly were not aware of. We don't read the gag order that way, and if that's the way that it's going to be enforced, we will take down the posts. Of course we will, and if we are directed to take down all of these posts, of course, we will comply. When you are thinking about criminal contempt and a willful violation beyond a reasonable doubt, it's important to look at, first of all, the first 3 posts that were the subject of the first order to show cause, which have nothing to do with those witnesses' testimony in this courtroom. And the reposts of articles that have been going on, for weeks. If that's a violation of the gag order, we didn't read it that way. And we will implement that and make sure that that doesn't happen. But certainly for all of the reasons that we've talked about, the president should not be held in contempt. If anything, the court should make crystal clear what it means with the reposts. And to the extent that Your Honor views the posts about Mr. Cohen and the system as being too close to the line, tell President Trump, tell me, and we will make sure that it's not violated. The court, as far as the whole distinction between reposts, you have stated it's ambiguous, you stated you didn't know, but again I hate to come back to this, but you are not offering me anything to support your argument. Mr. Blanche, but, Your Honor, the court was not done. You are not giving me anything to hang my hat on to say, yeah, you're right, the reposts, that was unambiguous, but as I've heard before, suppose someone outside has a placard, right, someone outside is walking around with a placard and it says some horrible, horrible things. Is it your position that if your client were to grab that placard and walk around with it and it said terrible, terrible things about the jury, that he has done nothing wrong because he didn't write that post or he didn't write that placard, therefore, he's absolved from any blame? Is that what you're saying? Mr. Blanche, it is nothing like what I'm saying. Your Honor, I'm saying this is a news article. That's different than a guy walking around with a placard. And you said I offered no evidence, no argument to give Your Honor comfort about the case law. This has never happened before. There isn't case law. But here is what we did offer, and it matters. Your Honor, there had been reposts, so we, of course, are trying to not willfully violate the court's orders. Okay, there are reposts that would appear to be similar to the ones that we are talking about today, and the people did not not hear because of those. And I agree with you, they have a choice, they can bring whatever they want, but that certainly goes to the willfulness. The court, all right, look, if it's your position that there were reposts and the court didn't act on it and the people didn't act on it, you are absolutely right, but if it's your position that because of that somehow that's probative of anything, we are just going to have to disagree about that. The fact that the people did not come running in here immediately when your client started reposting things, or that the court did not decide to summarily find your client in contempt, a decision that probably would have been overturned on appeal, is not probative of anything. You said, maybe we've gotten too close to the line. I think what you should have done is probably said, my client is thinking of reposting some things. It's not really clear to us in the gag order whether that's allowed. Judge Merchant, is that allowed? But that's not what you did. Mr. Blanche, look, Your Honor, the court, so let's take our break. I'm going to reserve decision on this. And we will reconvene at 11 o'clock. I'm sorry, you wanted to say something? Mr. Conroy, Judge, if I may be heard just very briefly, Judge. First of all, and this is obvious, Michael Cohen and Stormy Daniels are not defendants in a criminal case. Mr. Trump is. He knows exactly what he's doing. Judge, I would like to just hand up one more truth, and if you could hand a copy to counsel as well, that would be great. Mr. Conroy, and I think, Judge, the import of this is just that it illustrates what the defendant thinks about what happens when he posts something on Truth. It's a 2-page post. I'm just going to read it. It's from April 4th, 2024. One page, it appears one page of the post is about an hour earlier than the other on that day. But he's talking about his company Truth Social and he says, but when I put out a statement or message and I'm not sure what the distinction is in his mind, it is spread all over the place. Fast and furious, everybody seems to get whatever I have to say and quickly. So that's what we know about what the defendant thinks of his use of Truth Social. Judge, there is a lawful order here, it's very clear. The defendant has violated it willfully and knowingly by posting these posts, and we are asking the court to hold him in contempt. Mr. Blanche, quick scheduling question, Judge. The court, yes. Mr. Blanche, we are going to take a break until 11. Is it the court's intention to go from 11 to 2 straight? The court, yes, yes, it is. Mr. Blanche, all right. COURT, all right. Thank you, see you later. All right. I'm sorry, before you step out, I did receive your separate submission regarding the proposed limiting instruction as to the Wall Street Journal articles and the limiting instruction regarding AMI. The AMI limiting instruction that I came up with is really just a combination of the 2%, I took some from one and I took some from the other. The limiting instructions to the Wall Street Journal article, I basically adopted the defendant's version of that. Willie have made copies, and I will hand down copies when I come back at 11. Thank you. Mr. Conroy, Judge, one other thing, I said I would hand up a case, and I have a copy for the court and I have a copy for counsel. Thank you. The court, thank you. The clerk, case on trial continues. Appearances, please, starting with the people. Mr. Stanglass, for the people, ADA's Joshua Stanglass, Susan Hoffinger, Matthew Colangelo, Christopher Conroy, Becky Mangold, and Catherine Ellis. Good morning. Mr. Blanche, good morning, Your Honor. Emile Bowe for President Trump, who is seated to my left. And I am joined at counsel table by Todd Blanche, Susan Netchlees, and Kendra Wharton. The court, okay, good morning, again. I am handing down copies of the 2 limiting instructions, and it's 2 copies for each side. Mr. Bowe, just one point of clarification, Judge, with respect to the limiting instruction regarding the Wall Street Journal news articles. The defense has asked that instruction also be provided when the people offer exhibits relating to articles from the National Enquirer. And I think those are marked as the People's 152 and 153 the series. And I just the court, there may be an appropriate instruction that needs to be given at that time. The people have indicated that they might be offered for something other than what that says, so we will just need to customize it. Mr. Bowe, and I guess then the question is, are they coming in today? And how should we address that in the flow of the presentation? Mr. Stanglass, do you want me to answer that? The court, sure. Mr. Stanglass believe we will get to them today, but I think we had extensive colloquy on this matter last Monday when we argued why they should be admissible. And there is a host of reasons why they should be admissible. And this kind of gets to the point that we made in our response last night, which is that, the defendant is really not entitled to seriatim limiting instructions every time we introduce a piece of evidence. I don't think there is any law that requires that to be the case. I don't think they provided any law. The case that they provided doesn't stand for that proposition. And so I think that we can tinker with whatever limiting instructions are appropriate at the time that the court gives them, which in our view ought to be when the court gives all of its limiting instructions. COURT, and I think we will give instructions that will ensure that the jurors are not confused, and if that's at the time that it comes in or at the end of the trial or more than that, we will just figure it out as we go along. But certainly we want to ensure that no juror is confused. Mr. Bowe, thank you, Judge. The court, when the jury comes out, I do want to take a minute to just kind of clarify next week's schedule. I misspoke about a couple of things and I just want to correct that. The court officer, witness entering. The witness, David Pecker, enters the courtroom and resumed the witness stand. The court officer, step this way, sir. Step to the officer. The witness, okay. The court, welcome back, Mr. Pecker. I remind you, sir, that you are still under oath. The witness, yes, COURT, you can get the jury, please. The court officer, all rise. Jury entering. Seated. The court, please be seated. The clerk, the jury is present and properly. The court, good morning, jurors. Welcome back. Jurors, before we continue with the testimony of Mr. Pecker, I just wanted to clarify our schedule for next week. I misspoke yesterday regarding Monday and Tuesday of next week. Next Monday we are not meeting at all. There will be no work. Tuesday, we will be working all day. All right. Thank you. Mr. Stanglass, direct examination by Mr. Stanglass. Good morning, Mr. Pecker, good morning. When we broke yesterday, we were talking about Bonnie Fuller. And let me just ask you very briefly, during the period from 2015 to 2017, what was her title? Executive editor of Star Magazine. Are you also familiar with someone named Trish McAndrews? The name is familiar, but I don't recall. How about just Trish? Trish, yes, Trish was my assistant. You don't remember your assistant's last name, Mr. Pecker? That's not going to go over very well. Well, I always called her Trish for a number of years, very rarely saw her last name. Okay. So during the period from 2015 to 2017, was she your assistant? Eyes. Okay. Are you personally familiar with Donald J. Trump? Yes. For how long have you known him? Since the late 80s. Do you see him today in the courtroom? Yes, I do. Would you please point him out and would you please tell us something that he's wearing? He's sitting here. He is wearing, I think it's a dark blue suit.